Welcome to TFE Talks, Navigating Wealth, Business, and Legacy, the podcast from Thomas Fisher and Edwards. Each episode, our attorneys bring you expert insight on estate planning, business strategy, and legacy building, breaking down complex topics into clear, actionable advice. Whether you're solidifying a strategy we've discussed or preparing for what's next, this podcast is your resource for thoughtful, practical planning. You ready? Let's dive in.
Hello and welcome to another edition of TFE Talks. I'm your host, Jordan Goewey, and I'm joined today by a shareholder here at Thomas Fisher and Edwards, Matt Edwards. Matt is a shareholder at the firm and has been with the firm for close to 16 years now. He's a graduate of Furman University here locally in Greenville and is originally from Greenwood, South Carolina. He went to the University of South Carolina School of Law for his law degree and then went to Florida School of Law for his legal master's in taxation. Matt is a certified specialist by the South Carolina Supreme Court in estate planning and in taxation law. He's one of very few dual certified specialists in those two areas by the Supreme Court. And he's also an accredited estate planner by the National Association of Estate Planners and Counsels. So Matt, honored to have you join us for our first edition of TFE Talks and look forward to talking to you today.
Thanks, Jordan. It's great to be here. Happy to chat.
And so we've got a great topic here today. I think a foundational principle when it comes to estate planning, and it's very important that anyone that is working on their estate planning understands this topic, and that is how assets pass at death. I, for one, when I meet with clients, I tend to get clients who come in to meet with me and they think that they're just going to execute a will and that's going to control everything that happens when they die, and that they don't really have to think about any other aspects of their life or the types of assets that they have. But that's not the case, as I'm sure you will explain to us here. So, Matt, where do you begin that conversation with clients about how assets pass at death?
Yeah, when I meet with clients, I'd tell them really there's four primary ways that assets pass at death, and your will is only one of them. And your will is what people will refer to as probate, and probate's the court-supervised process of carrying out your will and distributing assets from your estate that go under your will. But there are really four ways, including the will. There's things that pass by beneficiary designation, items that pass by survivorship to the surviving co-owners, whatever passes under your will, and also things that are inside a revocable or living trust pass according to the trust.
And so that's a good way of breaking those into four distinct buckets. And so let's start with the first one you mentioned, which is assets that pass by beneficiary designation. That's certainly something that most individuals should be aware of, because most folks have retirement accounts, they have life insurance. And so why is that an important consideration in an estate plan?
Right. So the beneficiary designations that are attached to contractual rights like life insurance policies, retirement accounts, or some financial accounts like bank accounts and brokerage accounts, those are controlled often by a beneficiary designation, and your will not override that. And so I tell clients to make sure that their assets go where they want to by attaching to those accounts. Think life insurance, like we've said, retirement accounts, IRAs, qualified plans with an employer, to say, I want my assets to go to this person or this trust according to an attachment on that account to, say, either a primary beneficiary or an alternate beneficiary on that. Financial accounts like brokerage accounts and bank accounts can often have as well a designated beneficiary in the form of a pay on death or transfer on death designation. You'll see this as a POD or TOD designation.
And so, Matt, I think, when I meet with my clients, they really like beneficiary designations because it seems really easy, and they don't really have to deal with us attorneys and pay our hourly rates to manage their beneficiary designations. And then beneficiary designations also avoid probate. So why is it that clients can't just rely solely on beneficiary designations and just not even worry about preparing a will or something like that?
Well, there's a couple of reasons. One, that the beneficiary designation does not have the same contingencies that can be built into it, the layers that can be built in. So, for example, if a beneficiary designation says, I want my life insurance proceeds to go to my spouse, but if not my spouse, my kids, well, we don't know the order of passing of individuals. What if a child passes before you and they leave behind children? What if they leave behind children who are minors? Often we don't want those assets to go directly to a minor in that situation. And we may want to use a beneficiary designation to fund charitable bequests or have small amounts go directly to people outside of a general plan. The sending things either directly to individuals by beneficiary designation or more commonly for us in a trust allows a lot more complexity than the beneficiary designation will allow. For things like brokerage accounts, financial accounts with a TOD or POD designation, those, in my experience, will often only allow one beneficiary to be attached to that. And so if you designate, for example, your spouse to receive that, and your spouse passes away shortly before you, then that's really a failure of that beneficiary designation. And it would, in that case, fall in accordance with your general estate plan under your will and still be a probate asset at that time. So the beneficiary designation may not cover all circumstances, and so we want to have a will as a cover for those assets that lapse by designation and other methods.
And so simple is not always better when it comes to these sorts of planning techniques. So another bucket that you mentioned when we talked about the 4 ways that assets pass is survivorship. And you're licensed in the state of South Carolina, so we'll sort of limit our conversation to South Carolina primarily with this. But in South Carolina, how does survivorship assets work?
Right. The survivorship assets in South Carolina and many states, not all, would have the effect that when an asset is owned with a survivorship feature, when one of the owners passes away, the surviving co-owner or co-owners immediately become direct owners of that asset. So think often of 2 main types of assets. One being a joint bank account. If there's 2 owners on a bank account and one passes away, the survivor just carries on and takes that account as their individually owned asset. It doesn't pass by beneficiary designation, doesn't pass according to your will, but it passes to the surviving co-owners. You can have multiple co-owners on that, and so it would be shared among the survivors. For certain types of assets, like real estate in the state of South Carolina, real estate can be owned. Jordan, you and I can co-own a piece of real estate, and it would have both our names on it, but it doesn't automatically have a survivorship feature just because we are named as co-owners. Whereas if the piece of real estate it has a designation that it's titled as joint tenants with rights of survivorship, like my wife and I have, our primary residence, if I were to pass away, my surviving spouse takes that asset directly, doesn't pass under my will at all. Understand, though, that the survivorship feature only works if there is a surviving co-owner. If I passed away in my example about my primary residence, and then my wife took the house herself, and then she passed away, there's no more survivorship feature attached to that, and we'd want to cover that with a will or another method on it. In some states, like North Carolina, like I know that some of our attorneys are licensed in North Carolina, Georgia, and Tennessee. In North Carolina, surviving spouses are spouses who acquire real estate together. It's automatically survivorship. It doesn't have to have that magic language. So it's a very state-specific determination on the survivorship features.
Yeah, and another note that I'll make about that is that a lot of times I'll meet with clients and their house is titled jointly between the 2 of them, and they just assume that means that there's survivorship rights or that it's going to be joint tenants. And I would say in my experience, most real estate attorneys here locally were probably not preparing deeds that way up until maybe the mid to late 2000s. I don't know if your experience has been any different than that. So a lot of times my clients are surprised to find that their house that they bought 20 years ago is actually tenants in common, which is the default here in South Carolina.
Right, right. Yeah, I get asked a lot. I see that very commonly. We do work with real estate attorneys to change the titling a lot of times to make them survivorship assets, to add that joint tenants with rights of survivorship language by doing a new deed. And clients will say, well, why did my real estate attorney not do that? That's just a change in defaults of what we see in real estate practice in the industry. And we always check for that for our clients. We check to what is the titling, because it can make a massive difference in who receives assets and when somebody passes away and what rights people have at any given time. So we want to check that and verify it, make sure that it works for what the client's plan is.
And Matt, one other thing that came to mind as you were talking through these survivorship assets, it's of course fairly common for these to exist between a married couple. But sometimes I'll have a client who's a single individual, and they think that an easy way to avoid probate is just adding their child to either their home as a joint tenant with right of survivorship, or adding their child to a bank account, so that, okay, now it's just going to easily go to that child when I die. Why can that sometimes be a bad idea?
Sure. We generally advise against that. We don't say no, don't, absolutely, in no instances, but generally advise against that. And there's a couple reasons. When someone is a co-owner on a survivorship deed or a co-owner on a bank account, they have direct ownership rights. And those, even though a client may have given those rights to somebody else, the client can't take them back once they've been given them away. And so if there's a change in relationship, change of circumstances, change of plan, that bell can't be unrung in that situation. And so the client needs to think very long and hard about whether they want to make somebody a direct owner forever. If the property were to be sold, if it's a piece of real estate, then it takes both co-owners to agree to that sale. If it's a jointly owned bank account, each co-owner has the legal right to pull out the entire amount of that account. Better ways to do that exist in all of those instances. The other big thing is that when an asset is owned by each owner, that asset is exposed to each owner's creditors. So, for example, if you were to name your child as a co-owner of a bank account or a piece of real estate, and that child were to be subject to a lawsuit and experience a loss, that asset could be used to satisfy that claim and taken away from the client to pay the child or other beneficiaries' creditors at that time. So there's a huge risk of exposure on those assets when you name someone else as a co-owner. Better options exist for sure.
Yeah, I agree, and I advise my clients in a very similar way. So the other two buckets, and I'm going to kind of introduce these together, and I'll let you go in whichever direction you like, but the other two buckets are the documents that we help directly with as an everyday part of our practice, and that is a will and a revocable trust. Do you want to touch briefly on why you sometimes may want a revocable trust in addition to a will, and then what are the differences between the two? How do they work together, but what's different about them, and why do clients need to consider these other two buckets and how it ties in with their overall balance sheet?
Absolutely. So our will is for us often a catch-all. So everyone is subject to probate, which is, as I mentioned, the court-supervised and administered process of transferring assets that pass from an individual under an individual's name at death that don't pass by our other methods. And so probate is a process that is public. It's not a confidential process. It has costs and it takes time. So the costs associated with it, the probate court in the state of South Carolina and other states will charge a fee effectively for its services. You can think of it as a tax. You're paid to the government. You're required to pay it. And and just going through the process can be costly and timely. But a will is great in case there are things like I mentioned with the beneficiary designation or survivorship that lapse by other methods. For our clients, for my clients, I almost invariably will use a revocable or living trust. And that is, in a great sense, a will replacement. It's not a pure will replacement, but it does, as I describe it to my clients, all of the heavy lifting of the estate plan. So that my will says, whatever assets there are, send those to my revocable or living trust. And the will essentially just says, pay my bills, pay my taxes, do whatever needs to be done. And then the trust, in a private form, spells out what you would want to have your assets do at your death, who would to receive them, who administers those assets, who carries out your plan. And whatever is in your trust at your death or passes by beneficiary designation to your trust at your death remains private and bypasses the court-supervised process of probate. So very often, our beneficiary designations for things like life insurance or brokerage accounts, investment accounts, and bank accounts, those would say, at my death, I want this asset to go to my trust, and then the trust spells out the full plan, and we can do it in great detail. So as I said, set up trusts for surviving spouse or for children, hold things back for minor children until they reach an appropriate age, maybe have those protected from a child who can't manage their own assets. We can do all of that in a will. It's much more, in our experience, much more efficient to do that in a private form that doesn't incur the court costs or limits those court costs to a great extent.
And so 2 points off of that I thought of are, one, just because you have a revocable trust doesn't mean that we completely do away with these other mechanisms such as beneficiary designations. It's actually a nice way of tying those in together and using those in an efficient way. One point I'll make to my clients from time to time is that they can list their trust, as you mentioned, as the beneficiary of all of their various assets that have beneficiary designations, and then that makes it so that once they've made that change one time, if they ever want to make change to their trust plan, they've only got to do it in one place, in the trust. They don't have to go and reconsider all of those beneficiary designations again. So I think that's a key thing to keep in mind. And then also, I'll just note briefly that you focus there on the fact that a revocable trust is really just for probate avoidance. It's a vehicle for probate avoidance in addition to your will. And that does not mean that you have to leave assets in trust after your death. It could be a receptacle that is just there to help you avoid probate, but then it still distributes all of your assets out upon your death to whatever beneficiaries you want without leaving those in trust for a long period of time. It doesn't have to be a complicated trust mechanism like what we'll talk about in some future podcasts.
Absolutely. It really is a tool that allows us to minimize or hopefully eliminate probate completely. We use a will just in case we have some unexpected assets or unplanned assets that would pass through probate. But nearly all of my clients will use that revocable or living trust primarily for probate savings. And then we can have, as you say, as complicated and detailed and structured plans for estate tax savings and creditor protections for beneficiaries, and accounting for all of the different things that occur with a family and protecting beneficiaries when they receive assets.
And so, Matt, I think that's a great overview of those 4 ways that assets pass at death. A key goal of this podcast for our firm is that we want to be able to give people practical, actionable advice. And so the 2 items that come to mind to me just based on our discussion is, 1, simple is not always better. Don't just assume that all of my assets can pass by beneficiary designation or survivorship, so therefore I don't need to meet with an estate planning attorney and think through my plan as a whole. And then the second piece of it is on the flip side of the coin. After I meet with my estate planning attorney, the planning does not start there. I need to meet with my financial advisor or my other advisors or my banks, my insurance advisors, and so on, and actually coordinate my assets to make sure that they will be consistent with my estate plan and not upend my estate plan in some way. Would you agree with those two takeaways? And do you have any other final points that you want to make?
Yeah, absolutely. I think that it is a dynamic process. Estate planning is usually not one and done, not because the documents need to be changed many times, but you need to supervise and shepherd the assets that you have, because those assets change over time and you acquire new assets, or those assets grow, and maybe we want to do different things with that. But that needs to be a coordination process. We work very hard to work with clients, financial advisors, CPAs, insurance advisors, to align assets to the estate plan. We can do a lot of that. We can prepare the often more complicated beneficiary designations for retirement assets, do advanced charitable planning, fund assets like business interest or real estate assets into the trust to avoid probate on all those things. But those are things that can be done over time, and ultimately, if we miss something, that's what your will is for, to catch that, to send it to your trust. So it is a dynamic process. Many clients we meet with, and we had very long-running clients, and we'll make tweaks. We'll make changes. We'll move assets into trust, and we'll do different things. But it needs to be a conversation, needs to be a dialogue, and we need to understand, and we need to work with your other advisors to make sure the whole plan works coherently together.
Well, Matt, it was great having you on today, and I look forward to having you join me for future editions of TFE Talks.
Great. It was a pleasure. Thanks, Jordan.
Thanks for listening to TFE Talks. For more information, please visit our website at www.tfelawfirm.com. You can also follow us on LinkedIn, Facebook, and Instagram by clicking the links below in the show notes. If you have any questions about topics discussed in the episode, or you have recommendations for future topics, please email us at info@tfelawfirm.com. See you next time.